Good morning. This is the June session of the Court of Criminal Appeals in Knoxville. The panel this morning, to my left is Judge Robert Montgomery from Kingsport. To my right is Judge Kelly Thomas from Maryville, and I am Norma McGee Ogle from Sevierville. We would like to thank all of you for your cooperation in putting together this court session today. Also, our court staff, our troopers, the technology staff, part of whom are here from Nashville, have worked to try to make this efficient and work well for all of us. Most of you know it's 20 minutes per side, and if you want to have rebuttal time, please let me know before you begin. You're free to wear your mask or take your mask off as long as we can understand you. If we can't understand you, then we may have to ask you to remove your mask while you are speaking, but otherwise you're free to leave those on. I believe we're ready for the first case. Tennessee versus Revada, live.
This is a case that involves a conviction at the trial level of Mr. Wright based on constructive possession theory of right at 1 ounce of cocaine. And as the court, members of the court well know, a verdict, conviction for a criminal offense can't stand on conjecture, mere possibility, or speculation. And I would submit that the record before the court in this particular matter clearly shows that. And if this conviction is allowed to stand, that we are broadening the web of what constitutes constructive possession and the inference that can be drawn to create sufficient evidence for constructive possession in this particular case. And it's of course totality of the circumstances, and it's somewhat fact specific. But I would submit that the cases make clear, and I want to reference the Tennessee Supreme Court Robinson case, I think is very illustrative. But first, before you can establish beyond a reasonable doubt that a defendant has constructively possessed something, you've got to show that he knows about it, that he knowingly does it. And that's step one, I would submit, in the analysis. And then step two, if you get past the knowing part, does he have the power and intention to exercise dominion and control over it? So I would submit that it's really a two-step analysis, and that in this particular case, that the proof at trial fell short of even Mr. Wright knowingly, that he even knew about it, that he could have been, he was even aware of it, so you don't even get to the second step of the analysis. And there must be something to link the defendant to knowledge of the contraband in this case, and there simply wasn't. This verdict, for the jury to arrive at a guilty verdict, they had to speculate, and it basically rested on that speculation or suspicions and opinion evidence of Officer Owenby in this particular case. So as far as the facts of Mr. Wright, what do we know, and what was present and what wasn't present? Well, the initial stop was for speeding. It was a rental car. The proof was that Mr. Walker, the co-defendant, upon exiting, being asked to exit the vehicle, the officer noticed a bulge in his waistband. He did not notice it prior to Mr. Walker's exit. Mr. Walker moved his shirt in a particular sort of way, trying to pull it down or whatever. The officer noticed at that point the bulge in the waistband.
So did he ask them to step out of the car to begin?
Yes, my recollection was they were asked, not directed to, was I believe the testimony of the officer, and that was uncontradicted in the record of trial. But I think an important distinction that's in the proof is that Officer Owenby's testimony was that Mr. Walker, upon exiting, was very nervous, fidgety, things to that effect. And upon noticing the bulge, he asked Mr. Walker to pat him down, if he could pat Mr. Walker down. At that point, Mr. Walker agreed, but as the pat down started or whatever, Mr. Walker attempted to break free and run and was quickly taken down. In contrast, Mr. Wright, proof was that he was cooperative, was not nervous, provided his driver's license, things, and that there was nothing to indicate at that point anything suspicious regarding Mr. Wright. Based on that, though, based on Mr. Walker's attempted flight, Mr. Wright was handcuffed and taken into custody. He was searched. The vehicle was searched. There was nothing found in the vehicle unlawful. There were some cell phones, some drinks. There was some mention made that there was no luggage in the vehicle, and it was fairly clean. It was a rental. Mr. Wright volunteered that information that it was in fact a rental vehicle. But it's interesting when we look at what's not before the court, because all we have is contraband, cocaine concealed in Mr. Walker's waistband. And there's nothing to link Mr. Wright to that, which was certainly not in plain view. And I would submit plain view is an important consideration. Was
Mr. Wright the one who responded to the question about where they were going?
Yes, he was asked where they were going, and his response was either Maryland or it could have possibly been Maryville. If you read the record, the officer in his testimony initially says he said he was headed to Maryland, but then when that's followed up on cross-examination, could he have said Maryville? And he conceded that yes, he may have said Maryville. I'm on the side of the interstate here and it's loud. It wasn't that easy to hear. It's entirely possible that he might have said Maryville. There are some other maybe out of the ordinary, unpeculiar facts. Mr. Wright's asked what his passenger's name is, Mr. Walker. His reply is, I only know him by a nickname. The officer testified that once he activated his blue lights, that in his opinion, there was an exit that Mr. Wright could have taken and stopped on, but he chose to go on a little further and pull over on the side of the road. And maybe those are unconventional and out of the ordinary, but it's I would submit, vital that none of that ties him to drugs that are concealed on Mr. Walker. And I've got some cases that I want to speak of that I think highlight that. For example, case of State v. Jones, which is a 2020 Court of Criminal Appeals opinion out of the Western Section. The defendant there, this involved a hotel room. It wasn't a traffic stop, but there were multiple individuals there, contraband in plain view. No drugs were found on the defendant's person. The defendant in that case gave a false name. And that was part of the argument of the state. Well, them giving a false name can create an inference that they constructively possessed the contraband that was in plain view in the room. The two things we have there that we don't have here, one plain view, the other, well, no false name, but that still would require speculation. There are no statements of either Mr. Walker or Mr. Wright that are incriminating, that would suggest, as far as it directly relates to the cocaine that was found concealed on Mr. Walker. For example, by contrast, the 2010 Court of Criminal Appeals case, State versus Cole. In that case, the defendant, after being taken into custody, says to the co-defendant, we expletive up, we're screwed. How much time do you think we're going to get? In this particular case, the court found that would create a reasonable inference that the defendant constructively possessed the drugs. In looking at some other cases where we're talking about the I guess, odd or maybe obscure answer of, I'm going to Maryville or Maryland or wherever to pick up my sister to take her to the airport.
You would have to admit that's a little unusual, that, wouldn't you, that they're driving from Atlanta and let's say to Maryville to take a sister to the airport?
That doesn't sound like something that would commonly be done, but there's still no nexus between that statement and drugs found concealed on Mr. Walker. It's also
Other than it's back on the innocent. Rent a car in Atlanta, drive all the way to Maryville, take your sister.
Well, that could be true. Maybe you're seeing your sister for the last time. Let me.
Yeah, maybe there's more to it than he said in that answer to him.
Well, let me draw a comparison to the Transal case. I think I'm saying that right, but it's 828 Southwest 2nd, 949. It's a 1996 Court of Criminal Appeals case. In that case, the defendants found in a house, several people in a house. The defendant's in the bathroom and is heard flushing the toilet after the police come in. Well, what do we leap to there? There's drugs found throughout the house. What assumption do we leap to there? Oh, he's flushing drugs in the toilet. Okay, that's at least something our mind would obviously go to. He was also found several items of gold jewelry, a pager, and almost $500. And this is $500 in the mid-90s, which I would submit would equate to a little more this day and time. But no drugs were found on the defendant. Drugs were found in the co-defendant's bedroom. The court stated there, the court could speculate that he flushed the toilet to get rid of cocaine, but could also speculate that he legitimately just had to use the bathroom at the time the police came in. So I think that's important when we're thinking, well, that's strange that he would drive all the way from Atlanta, pick his sister up to take her to the airport, whether it's Maryville or Maryland. That's a pretty good distance. But that still requires, I think that's a good analogy to Transal, but that still requires speculation to leap to that. Now, if we had...
Let me remind you, you have about 2 minutes before you're into your rebuttal.
Thank you so much. Another case, Hilario Alfaro, I think I said that right. That's a 2014 Court of Criminal Appeals case. The police blue light individuals and they pull them over as they're going towards, or they see the driver and the front passenger, and the front passenger is the defendant in that case. And they see them both move towards the center console. before the traffic stop, or before they come to a stop after the blue lights. No drugs found on the defendant, drugs found in the console, no evidence the defendant handled the drugs, and no relationship between the defendant and the other individuals other than they were going to get a beer. Court in that state said moving in the direction of the console inappropriately expands the permissible limits of an inference for constructive possession. I'm going to try to hit real quickly before my rebuttal. What do we not have here? Well, we don't know what were on the cell phones because there's no evidence of anything that might have linked something. Maybe that something on the cell phones that would have created an inference. There's nothing in the car. There's nothing on Mr. Wright. I mean, this is not far of a leap from, say, an Uber driver taking a passenger and getting pulled over and finding drugs on the patron of the Uber driver. I mean, this is getting dangerously close to something like that. And so I would submit there's nothing even to get you to Mr. Wright having knowledge that drugs were on his passenger in this case. You don't even get to the second part of did he have the intention to constructively possess him. I would submit that's why proof's insufficient.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court, my name is Garrett Ward. I'm here this morning on behalf of the state of Tennessee in the matter of State versus Revada Wright. Your Honors, the sole question that defendant raises on appeal is a challenge to the sufficiency of the evidence used to convict him. He specifies that this challenge concerns the jury's determination that he constructively possessed a Schedule II controlled substance, in this case cocaine. Your Honors, the Tennessee Supreme Court has noted that constructive possession is an element that's often formed by circumstantial evidence. It's the rare case of constructive possession where there are sort of affirmative statements proving, sort of affirmative statements that directly speak to the defendant's knowledge and ability to exert dominion and control. And in that vein, Tennessee courts have noted that, look, we ask the juries to look at the totality of the circumstances in these cases and allow them to examine these circumstances and from this circumstantial evidence reach a finding of constructive possession. And that's precisely what the jury did here. Your Honors, this case rose out of a traffic stop. The defendant was driving a car. He had one other passenger. He was pulled over for speeding. During the course of this stop, the officer Owenby, who initiated the stop, asked.
Well, you would think if he knew about the drugs, he wouldn't be speeding, wouldn't he?
Perhaps avoiding speeding would have been a good course, but that was the genesis of the traffic stop, Your Honor. And it's interesting to sort of look at the very initiation of this traffic stop because the officer testified that after he activated his blue lights at mile marker 26 on I-75, that the car, which was being piloted by defendant, drove for what the officer considered to be a suspicious amount of time, a little over a mile, to pass an exit ramp, which was located at mile marker 27.
And you also, I thought about this, passing an exit ramp. That could go the other way too, as well. If the officer could think he's taking off on that exit, he's trying to avoid being stopped.
Perhaps so, Your Honor, but the jury's finding was not solely based on this, what the officer described as a suspicious delay. The jury also took into account the circumstances concerning the purpose of the trip that the defendant and his passenger purportedly were on, and the nature of the relationship between the two men. Your Honors, after this stop was initiated, Officer Owenby inquired as to what the purpose of the trip was, and the defendant provided that he had rented a car in Atlanta where he lived, and that he was driving that car either to Maryville or Maryland to pick up sister and take her to the airport. Either way, Maryville or Maryland, from Atlanta, the defendant is suggesting that he's taking a rather lengthy journey to pick up his sister and take her to the airport, which is odd to say the least. However, that the circumstances relied on by the jury do not end there. On top of that, the defendant provides that he doesn't really know the passenger, that he only knows him by a nickname, and the passenger provides that he has agreed to go on this journey while carrying about 30 grams of cocaine on him, that he has agreed to go on this journey with a man who does not know his name without ever knowing the destination.
There was no luggage?
No, Your Honor, there was,
Nothing? I mean, I'm trying to remember, was there like fast food type stuff in there? Trash?
I don't specifically recall, Your Honor. My recollection of the record is that the car is essentially empty, aside from the defendant, the passenger, and I believe a couple of cell phones. There may have been, a can of Coke or some
Rented in,
wrap.
was it rented in Atlanta?
The Atlanta area, yes, Your Honor.
We see a lot of cases where people who have spent a lot of time together, they only know nicknames. Years ago, I thought that was unusual. But you see that more and more often. Ask the real name. They don't know it. They just know him by a nickname.
Your Honor, I think when looking at that fact on its own, that fact on its own probably would not be enough to support an inference of knowledge of contraband and ability to exert dominion and control. But we direct Tennessee juries to look at the totality of circumstances in these cases. You have this odd nature of the odd purported nature of the trip, traveling at minimum 3 hours. I'm not entirely certain how far Maryland is from Atlanta, but quite a distance. But at minimum 3 hours, 2.5, 3 hours from Atlanta to Maryville to take his sister to the airport with a man whose name he does not know, where this man who's carrying, a felony amount of cocaine has no idea where they're going. When you combine sort of the odd nature of the trip, the odd nature of the relationship between the two men, with the suspicious delay in pulling over where the driver disregards perhaps the safest spot to pull over for a stop on the interstate, exiting a high-speed area of traffic to an exit ramp after traveling a little over a mile. When you look at the relationship, the nature of the trip, the circumstances specifically surrounding the stop, combined with the large amount of contraband found in the vehicle, which the Tennessee Supreme Court has noted does suggest, can be viewed as evidence that supports a finding of constructive possession. When we look at all of these circumstances in totality and do so in the light most favorable to the state, a reasonable juror could conclude that the purpose of this trip is made up, that the purpose of this trip is to transport contraband, and that the lengthy delay between the blue lights being turned on and ultimately stopping is to remove this contraband from some more easy to discover place and hide it on the person of the passenger. That's what the jury did here. This was a reasonable finding made by a rational trier of fact. And I would ask this court not to disturb that finding on appeal. If there are no further questions, Your Honors, I would ask that this court affirm the judgment of the trial court.
Thank you. This world's full of, I guess, people that march to a different drummer or go where the wind blows them or don't have as much of a conventional lifestyle as maybe some people do, and might do things that we think are, well, I wouldn't do that. That's kind of strange. That's out of the ordinary. That doesn't make it illegal. Most of us probably wouldn't hop in the car to drive 3 hours to take our sister to the airport. We might if she's going to Hawaii and we're not going to see her for a long time, just to say hello or whatever. I think that's in the proof precedent today, I promise you. But there was this place in Denver. He's in Memphis at Graceland. And there's this place in Denver that just, he thought had the best peanut butter sandwiches in the whole world. So he calls his pilot, says, gas up to Lisa Marie. We're going to Denver. Flies there for a specific purpose of getting the peanut butter sandwiches and comes straight back to Graceland. I dare say probably none of us, first of all, I don't know that any of us would have the capability to do that, but nonetheless, the initiative to do something like that. So are there some odd facts here? Sure. There's no, the no luggage maybe is a little strange, but that was in the Cole case, 2010, there was no luggage. The driver exhibited nervous behavior. The key distinction there, though, is where they have the statements, I would suggest, by the driver that we screwed up. How much time do you think we're going to get? We won't have anything like that here. I mean, so the peculiar facts do not create any nexus to the cocaine that was clearly on Mr. Walker. And let's not lump these two, I mean, they were co-defendants, but it's very, I mean, obviously Mr. Walker has actual possession of it, but it's not like he's waving it around and saying, hey, Mr. Wright, look at my cocaine. It's concealed. There's no proof that anyone saw it. Actually, until it came out, saw a bulge, the officer first said, I thought it might be a gun. That was kind of his first assumptions, which understandably, why? You pull somebody over on the side of the highway and think they've got a gun, that's your first concern over cocaine if you're law enforcement. I understand that. But keep in mind the Richards case, and the appellee cites the Richards case in their brief, and they cite the dissent actually, but in that case, there's I think four people, at least three, but I think four, sitting at a picnic table. And the police get a tip, they show up, they see one person get up and brush their arm, and see white powder there. Another person has white powder in the seat of their wheelchair. And Richards, the defendant, is at the table, but is not found doing any of that activity, dropping drugs or swishing drugs away off the table. That case found that it was dismissed and upheld on a motion to suppress. So they didn't even find probable cause for a search of Richards, because they were found at the table with but with nothing on them and not doing any of the suspicious activity. Now the dissent in Richards says, well, plain view is very important. I dissent, I think it supported a search because the defendant's at the picnic table with these other three and the drugs are in plain view. Here we have exactly the opposite. So again, I submit you don't even get past the first prong that's required to establish constructive possession. First, there has to be proof beyond a reasonable doubt that Revada Wright knew these drugs were even there. You can't even get there on this record. So you don't even get to the question of did he have the intention to exercise dominion and control over them, because no one saw them until they fell out of Mr. Wright's waistband. And so I submit for that reason, we take that leap. If this conviction stands, then we take that leap to constructive possession being supported not on a reasonable inference, but on speculation, and you have to guess. And that's why I respectfully submit that the court should overturn this conviction and vacate the judgment.
Thank you.
Thank you.
I believe that concludes our morning docket. We will begin again at 1:30. The court will be recessed until that time.
All rise.